And then the speaker obviously had to be out of the jurisdiction. There can't be a vacuum. Somebody necessarily has to step in.
Well, I will allow.
It's just an academic exercise.
I will allow the supplementary question subject to the aspect that says the vice president is ill, because the Constitution used the expression absent from the jurisdiction. So, my Lord, you may proceed to answer the question.
Thank you, Mr. Speaker.
Thank you. You know, there have been two Supreme Court decisions on what do we mean by absence of the president, vice president, or the speaker. And it is the interpretation that has been given. And to me, that interpretation to me, contrary to purposive interpretation. Because we must look at the purpose for which the law was made. And why do we talk about purposive interpretation? Purposive interpretation means we look at the purpose, and the purpose is determined by time, circumstances, and development. The things that we had 20, 30 years ago, they are not the same as now. So I believe if in future that there should be a decision, the time and the circumstances may change the decision that the Supreme Court may render. It is possible. And we are saying that the Constitution is a living organism capable of growth. And the Constitution can grow at any time, and the meaning can change depending on time, circumstances, and development. Thank you.
I will then give the floor to Honorable
Last follow-up. Last follow-up.
Bafo.
Mr. Chairman, aren't you enjoying the
discourse? You have exhausted your limit. The majority leader wants a follow-up.
Yeah, but Justice Dennis, if you look at the provisions of Article 60, they clearly anticipate, and I do agree with you, that if the president is not there, the vice president is not there, the speaker. If all of them are not there, the vice president and the president are not there for a given period, the assumption is that, let's say if they are not there and will not come back, if they will not come back, then there must be an election in 3 months, and a new president will have to take over. So clearly the Constitution is firm on the people who can occupy the position of president or acting president, and for what duration they can act as president. So what could have necessitated an arbiter to the effect that Chief Justice can act as a president? What, on the basis of which provisions did that come up?
Thank you. It was by Professor Kruje in the case of a Sarabes Attorney General, which I personally, even though it is an arbiter, I disagree. Because if you are interpreting, you must interpret within the context, and you must be fair. You must be fair to the text. Faithfulness, that is cardinal principle in interpretation, faithfulness to the text. Where it has not been stated anywhere, but I do not blame him, because he was discussing the position of the law between 1957 and 1960, where in the absence of the Governor General, all the bills were signed into law by the Chief Justice. That was the position then. So he used that one, because that regime, the order in council 1957, is different from 1992 Constitution. So at no point in time can you compare the two. So if you look at, he was influenced by that position, but within the context of the Constitution, it cannot be so. Thank you.
Is it desirable in the context of separation of powers to ever place the head of the judiciary as the head of the executive?
No, please, because we had one in 1957 which brought about problems. Whenever there was a bad law, like PDA, deportation order, the Governor General, Lord Listowel, will travel to England and the Chief Justice was signed to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice, because why do you involve a judge or Chief Justice whose role is resolution of disputes, which is different from the role of the executive? If it extends to Parliament, there's nothing wrong, because they are politicians. They were voted for. They put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.
Now, looking at, I think from your previous answers, you seem to me as a judge who has some belief in the purposive approach to constitutional interpretation.
I have several publications on it. Thank you.
So you endorse purposive interpretation?
But leader,
of constitutional
do I take it that you are now having your turn?
Yes, I'm having my turn.
Very well.
You endorse the purposive approach to constitutional interpretation?
That is so.
Now, Article 60 talks about two scenarios: absence from the country and inability to perform your functions. From a purposive approach to interpretation, in this era where absence from the country is not the same as inability to perform your functions, in view of developments in telecommunications and etc., where you can even sit abroad and then chair a cabinet meeting, where you can sit abroad and receive briefings. In fact, on your aircraft, you can actually chair a cabinet meeting taking place in the Flagstaff House. So on a purposive interpretation to our Constitution, given that the Constitution is anticipating absence from Ghana based on an assumption in 1992 that when you are physically absent, you will not be able to exercise your function as president, or where you are actually here but you are unable to perform, maybe due to ill health or some other consideration. Given that that is not really something that practically exists now, can we say that at any moment a president is absent from Ghana and as a result unable to perform his functions, by which reason, when both president and vice president are not there, there is a fundamental breach of the Constitution?
Thank you, Chair. When we talk about unable to perform his function, and it is outside or he's outside the jurisdiction, and if you look at the decisions rendered by the Supreme Court, the one against Honorable Adjei, the Supreme Court said that no, the person must be physically present in Ghana. That was the intention at the time the law was made, because we were scared of soldiers, that at the least the soldiers will come. And therefore, as a commander-in-chief, if you are not there, somebody should take over from you. And as I said, when we take into account purposive interpretation, what we do is that we look at the law. We look at having looked at the law, then the next thing that we do is we look at the context within which it was made, context. So having taken it out of the context, then we move to the second stage. We look at the purpose, the subject matter, the scope, and to some extent the background. What informed that? The background, does it still prevail? So I believe if there is a new application, nothing will prevent the Supreme Court may take into account technology, development, and move to different level. Nothing may prevent it, because if it is to be construed purposively, then whether the president is in Ghana or not, provided he's not sick, he's not seriously sick and can perform his function, I don't think this should be a critical issue. Thank you, Honorable.
And can you reconcile a situation where the president is attending the United Nations General Assembly on behalf of Ghana in his capacity as president. He's there in his capacity as president, sometimes even on a state visit in his capacity as president. And then in his absence, the vice president is sworn in as the acting president. At that time, do we have two presidents for Ghana? The vice president is acting as the president. Yes. So the point I'm making is, do we have one president acting outside Ghana and another president acting in Ghana?
Thank you, Honorable Chair. Honorable Chair, that is why from the beginning I said that there is an issue with that decision, but it is binding on everybody until it is varied or set aside. But as you know, Supreme Court decision can change at any time, provided it is policy, such as this one. It can change at any time. That is why we say that it is a living organism capable of growth. And in the case of Zenita Lawrence, Justice Tuguba openly stated that because of modern purposive approach or purposive approach, meanings can change at any time. And therefore, if you go for even interpretation and you think that the meaning has changed as a result of time, circumstances, and the purpose, you can still go back to the same court. So I am of the considered opinion that now that we have modernization, technology, and those things, that position, in future, if the opportunity avails itself, it should be changed. Thank you, Chair.
That will not amount to rewriting the Constitution, will it? Because the language of Article 60 is quite clear. The circumstances have changed. That renders its application funny, if I may put it that way. But the language hasn't changed, and the language is not open to different interpretations and fidelity to the language of the Constitution. Will you keep changing the language of the Constitution because circumstances have changed that make its application quite, uncomfortable?
Thank you, Chair. Yes, that is why now in most countries those use constitution. They are talking about either living constitutionalism or purposive interpretation. Whichever you look at it from, if it is a living organism, if at the beginning it was at the ground level and circumstances are changing, the constitution will grow. And that one, it will not materially affect the substance. It is the meaning that you are going to attach to it. And either you use purposive approach to interpretation or the living organism, which the Constitution is supposed to grow, which Ghana has embraced into 4 and Attorney General. It has been celebrated that the Constitution in Ghana will grow. Otherwise, if you talk about pedantism, then we are going to talk about literalism. The Constitution will never grow, and it will cease to be a constitution. It will be treated like any other document, such as Ordinary Act of Parliament or CI or LI. But the Constitution is different. That is why we say it is sui generis. It is unique, and because it is unique, its interpretation may change depending on the circumstances, but it will not affect the substance of the law. And what I would also like to say is that when we are talking about living constitutionalism or purposive interpretation, what we seek to do is that the Constitution must be able to address normal and or abnormal circumstances through proper interpretation. Thank you.
I'm being gagged by my chairman. He says that I've asked enough questions.
No, it's far from that. I will then proceed to give the floor to Honorable Ewa Bafo.
Thank you, Mr. Chair. The tempo has been a bit up, so let me bring it down. Congratulations, my Lord. My Lord, from your CV and your own account, before joining the bench, you practiced as a lawyer from Holy Trinity Chambers. Can you please, by way of clarification or information, let us know whether it's a partnership or a limited liability company or a company on limited by shares?
Thank you, Chair. Chair, in Ghana, you can register a company, a law firm, as either sole proprietorship unlimited liability or partnership.
My Lord, I want to know whether Holy Trinity, what is its legal
sole
status?
proprietorship.
What you want, but it is the answer that the nominee wants to provide.
It was registered as sole proprietorship, and it was Dennis Adjei legal consult of Holy Trinity Chambers. Why we do not allow companies to be registered in Ghana as a limited liability is that once you own a firm, your liability is unlimited. Because if you dupe somebody, you use fraudulent means to take money from your client, and you say that it is limited to my shares. No, it is limited to your own properties. That is why no country allows a company to be, a law firm to be registered as a limited liability. It can be unlimited, partnership, or sole proprietorship. So Holy Trinity was sole proprietorship.
Now to my substantive question. I wanted information.
You don't have a preliminary question and a substantive question, so you can either ask a follow-up.
Mr. Chair, very respectfully, the basis for my question was the reason why I sought clarification.
Honorable member, you are entitled to one question. You have asked the one question. So if you don't have a follow-up, let me give the floor to another person.
What do you make of a lawyer who maintains an interest in a firm after he has joined the bench? What do you make of it? Is it appropriate?
Honorable member, this cannot be a follow-up question. The question is accordingly overruled. I will then proceed to give the floor to Honorable Akurugu.
Thank you, Mr. Chair. Congratulations, my Lord. Yes, your students you've taught before speak highly of you, your human relation, and your command over the law. And you make law so easy. And I think based on that, I had an encounter with you, and I was contemplating going to read law. But there is this issue concerning about expanding access by breaking the monopoly of Ghana School of Law in the training of lawyers. Do you agree to this suggestion, and what reforms would you suggest for the legal education in Ghana? With regards to Makola, you go to do your LLB, then Makola. So, thank you.
Thank you very much. Yes, my Lord.
Thank you very much.
Your answer.
The legal education in Ghana is confronted with multiples of issues. Initially, we had it only at Makola, but we had emerging universities. So the students were not getting admissions. Then it was decided that we should have 2 campuses. Then we have Gimpa and Kumasi. Still, there is an issue. We have an issue. The issue about admission, even though last year the law school tried to admit about 1,400 students, but how many students are turned out from the universities every year? We used to have only 3, 4, 5 universities, and now we have about 13, including those who do this outside the country. So at the end of the day, if you look at those who sit for the entrance exam, you may get about 3,000, 4,000, and the school can take only about maximum 1,400 students. So here, there could be a policy decision. The policy decision that I read online was that why don't we allow some of the schools to do the bar, and we use the law school as we use the law school as examination center, accreditation, monitoring, and evaluation, and other departments to ensure that the integrity of legal education is not compromised. So we can have it. We can have, because it is a policy decision, and as a judge, I don't want to delve into policies. But what I would say is that if the most important thing is that if feasible studies have been done and it has revealed that this one is better than what we have now, there is nothing wrong. I will only have an issue with it where there is no feasible studies, where there's no feasibility studies, and we are just jumping the gun. But where we are satisfied that we have examined this, and this is the better option, we should go for it. Thank you.
Any further question?
Mr. Chair, no further questions. Congratulations once again.
Thank you. I will then proceed to give the floor to Honorable Anthony Imie.
Thank you, Mr. Chairman. Congratulations, nominee, on your elevation. You're almost there, if you pass the test. Now, let's look at AI, artificial intelligence. With the emergence of artificial intelligence and the spread of fake news, fake accounts, would you support the criminalization of misinformation, disinformation, and the posting of or setting up of fake accounts? Would you support that?
Yes, please, because if you do it ordinarily, it is an offense. And therefore, if you transpose it to social media, it should be an offense. Thank you.
Now, don't you see such a legislation as a threat to free speech?
No, please, Ghana, we have the Communication Act. The Communication Act has criminalized some acts. Because, for example, if you want to expose the nudeness of somebody, you are saying something that is prejudicial to the security of the state, and you do it on social media. If you do it in the country physically, it is an offense. And therefore, if you do it on social media and it is an offense, it is not an extension of anything. Assuming it is not an offense if it is done within the jurisdiction, and you do it on social media, and we are criminalizing it, that one, it will be wrong. But if you do it in Ghana, physically, it is an offense. So wherever you do it, it should be an offense.
Any further question?
Thank you very much. My next question. My Lord, recent surveys by Afrobarometer, Global Corruption Barometer, Ghana Integrity Initiative, etc., suggest a decline in public confidence in the judiciary. What specific reforms would you propose to restore trust in the judiciary?
Thank you, Chair.
Yes, Honorable Nominee.
Chair, when I was the Director of Judicial Training, we decided to make ethics a component of whatever training that we give, either to the judiciary, the judicial officers or staff. The reason is that when we are talking about corruption, we are talking about something which is bad, then we must make it a conscious effort to fight it. If you do not fight it, it will become endemic. And therefore, the most important thing is that we need to first and foremost conscientize ourselves about the effect of corruption. Then the second one, what do we do to curb it? We need education. We need training. Then one thing that people of Ghana that you don't do is that if a public officer, either me or any other person, demands money from you, you must report the person. You will condone. You give it. Then when it comes to assessment, you say that you will not mention the name. Then say that the whole judiciary is corrupt. That is the problem, and it is about perception. And I can talk about personal experience as a director of the Judicial Training School. On one occasion, I was training. Then somebody came to me to complain about somebody who was taking money from him. We made the inquiries. I was the director of the Public Complaints Unit of the Judicial Service. We investigated. The person who allegedly took the money from that person entered the courtroom and bowed to the judge. The judge did not know him. Just to give it a semblance that he had given the money to the judge and was coming to bow to show that the person who is accompanying him is the person who gave out the money to him. But it was false. So these are some of the things that we do and we must stop. In most cases, if you listen to some of the TV discussions, social media, you know, instead of bolstering the faith of people in the judiciary, we are rather saying that the judiciary is corrupt. But if you ask for evidence, then we say it is perception. So the most important thing is that we must be bold. If we have physical evidence, we must use to substantiate. Otherwise, we shall be talking about perception, because any person who goes to court and loses, the person's position is that because he did not pay bribe, he or she has lost. But it is not the matter. The case is bad. So apart from training, we need to conscientize ourselves. Then the third antidote is that if a public officer corrupts himself, that person must be prosecuted. Thank you.
Now, my last question. In your view, how should the Ghana legal system evolve to address matters like climate change, environmental degradation, resource extraction? Let's take into consideration the current issues related to Galamsey, which has been ongoing for some time now. How should our system evolve to nip all these menaces in the bud?
Thank you, Honorable Chair. Honorable Chair, we talk about judiciary, and the judiciary, we are moving from the traditional judiciary to the modern judiciary. Now, Judicial Training Institute, we teach environmental law for judges to equip their capacities. Unfortunately, most of them do environmental law at the faculty. Law school is not done. But when they come to the judiciary, the initial training, it has been incorporated, the induction, as part of the system. Then in addition to that, we have continuous judicial education. And these are the things that we introduce to the judges. And was it 4 years ago, there was a case in Takwa where the judges was accused that somebody was involved in illegal mining. It was brought before the judge. The judge sentenced the person to 6 months. I called for the docket on behalf of the Chief Justice. I was then the director of the Judicial Training School. When it came, the police did not prefer mining offense. The charge was trespass. So if you haven't seen it, you may believe that the person has committed offense under the Mineral and Mining Act, and the minimum sentence ranges from 5. Meanwhile, the police who arrested that person preferred the charge of trespass. So we need to build the capacity of the judges. And when I was the chairman for the African Judicial Network on environmental law, I made sure that the selected countries, the pilot countries, Ghana was one of them. So they gave Ghana, is it about $60,000 or so, judiciary, to have a manual to train on environmental law. And I made sure that the contract was awarded to a Ghanaian. He was Mr. Asumda. He used to be the dean of Zenith. I don't know whether he's there or not. And he prepared it, we validated it, and it became the property of the judicial service. So these are the things that we need, because environmental degradation, air pollution, sea pollution, illegal mining. If you do not fight, it will fight us. So what I will conclude is that, yes, we need to build the capacities of the judges as well as lawyers, so that when we get cases involving those matters, we will not fall short. We will do justice to what the law says. Thank you, Mr. Chair.
Now my last follow-up question. How would you balance swift environmental protection through deportation against due process rights in criminal law?
Honorable Chair, I will use my position as the chairperson of the African Judicial Network on environmental law. We use the two together. It is a tool that you need the two. You must take drastic decisions in environmental law, at the same time pursue criminal charges against them. Because if you do one to the advantage of the other, that means those who are not within the net, they will not be caught. So ideally, we need the two to fight. It is not an alternate, it is joint. Thank you.
Thank you very much. I'll proceed to give the floor to Honorable Alhaji Omar. Honorable, you have the floor.
Thank you, Chairman. Sir Dennis, congratulations, my lord. I want us to talk about this house, Parliament. Of late, we've been having some challenges about the privileges and immunities. And I would like you to tell this committee how best, or what are the privileges and immunities, and how best can we safeguard it. Thank you.
Thank you. Parliament is likely to lose its existence if it loses its privileges and immunities. The privileges are the additional rights that are given to members of Parliament to enable them to function. That is, they must be bold and they must hold government accountable. But if the privilege is not given, or the immunity, they are not immune from acts such as being arrested. We have said that at Parliament, you have said something, then you are hunted for, you are arrested. Then that means the whole immunity is gone. You are immune from some of the laws that ordinarily would have constituted crime, but you are immune, crime or civil wrong, but you are immune from that one. Honorable Chair, let me give you an example. In 1215 AD, when the Magna Carta was signed by the dames, the barons, on the other hand, and John the King, it was 1215 AD, meaning we are ending rule by law, we are moving to rule of law. Now, when they moved, and Parliament insisted that they needed immunity, the monarch said, we will not give you immunity, otherwise we'll be at par. And they fought for 474 years until 1644, when the English Civil War. The English Civil War was brought about the rift between Parliament and the monarch. Monarch was eroding Parliament of its privileges and immunities. That was why they fought. And fortunately, Parliament was able to overpower the monarch and overthrew monarch. That was where Cromwell became the president. They changed from monarchy to republican. And when Cromwell died, his son, Richard, took over. Richard was also messing up. Then they went back, that we should go back to the monarchy. And the monarchy, they brought in James II. What happened? When James assumed power, James said, Parliament will not allow you to exercise freedom of expression. Closed book doctrine will not allow you. We shall interfere. You know, it brought about another war. And that war, James ran away. And that brought about the first time that we had a male and female monarch coming together. That is Mary II and William III. When they came together, then they were forced to sign the Bill of Rights of 1879. And when it was signed, that was where it said that Parliament, you have immunity. You can have closed book. When you have matters before you, the court cannot come in. The court will come in after you have decided and the outcome offends any law. Then when you go to Parliament, you have absolute privilege in terms of what you discuss and what you say and what you debate, unless you are stopped by the speaker and you fail. Then that one, the speaker may deprive you of your immunity. Then they said that if you are talking about Parliament, it should not be limited to only Parliament House. Parliamentarians attending committee meetings or any meeting initiated by Parliament. That was how all these things came about. So now, all these things came about, and the Parliament in UK is the strongest in the world. And if the law, the Constitution has given it to us, and we do not defend it jealously, then a time may come that Parliament may lose its relevance. We must guard jealously against the executive and judiciary encroaching into your closed doors business. Then the time may come, you cannot even argue because they will come and tell us what is going on. Thank you.
Thank you, my lord. And we will guide it jealously.
Any further question?
Yes, I have one more. I have one more. There have been two. Thank you so much for the education, anyway. Second question. There have been two conflicting decisions of the Supreme Court in respect of its enforcement and interpretation, jurisdiction under Article 2 and 130 of the Constitution. What is your opinion or position?
Thank you very much. Now, unfortunately, it has come to an end, but let me state it. The Supreme Court had two conflicting petitions, but in law, when we talk about enforcement of Constitution, we are saying that identify the law, implement it, that is, identify it and implement and make it applicable. That is what we mean by enforcement. But when we talk about interpretation, we are saying that it is either unclear, ambiguous, and therefore you need interpretation, or the two parties have put on two rival meanings, or the two enactments in conflict. There are two provisions of the Constitution which are in conflict, or the Constitution has set up a body, and the operationalization of that body cannot be done because of the provisions in the Constitution. Now, there was no ambiguity as to the enforcement or the interpretation. But Supreme Court, when it was composed or presided over by one particular judge, then the word or, enforcement or interpretation, the word or remained or. But whenever another presiding judge was on the panel, then the word or became end. According to him, if the word or remain or, then there will be, Supreme Court will be inundated with cases. All cases will come to the Supreme Court. But if you make it enforcement with interpretation, then you cannot come to the Supreme Court only for enforcement. It must be enforcement with interpretation. But the irony was that Osei Boatin versus Ghana Media Commission was where the two heads met. The one proposing end and the one proposing or. Then fortunately, the one proposing end had a majority, and the one proposing or had a minority. And in his dissenting opinion, he said that I perpetually disagree. And fortunately, the one who said end retired. And the next case that came, Call versus Attorney General. So the one who said or was presiding. So he had the majority, and he said that the word or is or. And the Supreme Court went ahead to say that all the decisions that held that the word or should be end had ceased to be good laws and should not be followed. So now it has come to an end, provided another set of people will not come and take it from another angle. Thank you, Honorable.
Thank you, sir, and I wish you well.
Thank you. I'll give the floor to Honorable Patrick Hialboma.
Thank you very much, Chair, and congratulations to Sir Dennis Adjei. And to your big CV Fats well behind you. And I want to ask you, sir, the Catholic Church has a position on gay and lesbian rights. And you know, our laws also frowns on those practices. Definitely, you've heard some of the debates and arguments on some of these things. And there hasn't been any definite pronouncement by the Supreme Court. I'm not asking for your opinion should this matter come to you, but how would you marry this issue? when it comes before you. Thank you.
Thank you, Honorable Chair. Honorable Chair, we talk about our faith, it could be Christian faith, Muslim faith, it is your faith. Then when you are in the courtroom, you have taken judicial oath. That I shall not be impartial, irrespective of the persons involved. So once you put on your judicial cap, you must bear in mind that you must perform in accordance with the judicial oath that you have taken. So to me, if any matter is brought before me, whether it is same-sex, whether it is whatever, when it comes before me, I will look at the circumstances, the law, and I will give effect to the position of the law, without being influenced by my faith. Otherwise, I will abdicate my seat as a judge. The African court is worse. You know, African court, we handle only human rights cases. These are some of the cases that come before us, but when they come, we handle. We don't put on our faith, because if we put on our faith, then a time may come, every religious sect would insist that I should have a judge on this panel. Otherwise, if a case comes, I will not get what I want. But that should not be the position. Thank you, Honorable Chair.
Thank you, Chair. I don't have a follow-up question on that, but in your CV, Sir Dennis, there's nothing about sports. It's all about academic work, and book. My Lord,
what is the meaning of book and Kwan? At least for the record.
There's a scholar throughout his life, and must commend the gentleman from Esoyabo. My Lord, you've had extensive experience in judicial education. As a former dean of Gimpa Law, director of the Judicial Training Institute, and currently on the international judicial bodies, including ICC Advisory Committee, the African Court on Human and People's Rights. How would you leverage this experience to strengthen judicial independence in Ghana? And what reforms will you propose for continuous judicial education to ensure that our judges remain current with evolving legal principles whilst maintaining their independence from external pressures? Thank you.
Thank you, Honorable Chair. Honorable Chair, first and foremost, I will refer to our Code of Conduct. Our Code of Conduct talks about impartiality, independence, conflict of interest. So if you are a judge, once you take the oath, then you are bound by the judges, the Code of Conduct for judges and magistrates of Ghana. And you get all these things from it. We need to continue educating our judges and magistrates. That is the first one. Then the second one, we have the Bangalore Principles of Ethics. And we teach. It is an international principle that whether you are a national judge, international judge, you must know. Because it will tell you that once you are a judge, you must identify yourself as a judge, and always have in mind that the executive and the legislature should not have any influence on you. And we even go ahead, apart from institutional influence, we also go ahead to talk about individual independence. If you are a judge and you are sitting on a matter, if you allow any person to influence your conduct, that means you have lost your individual independence to sit. So, Chair, what I would say is that, well, by God's grace, I have acquired international experience from the International Criminal Court. And when I mentioned the chairperson for the African Judicial Network of Environmental Law, it was all the judicial trainers in Africa. When we met, I was elected the president. That is what it means. And I go to other countries to teach, to train them. Even Tanzania some time ago invited me to help them draft their bench books. I've been in Sierra Leone. I've been in several countries. So I believe that with the cooperation of the authorities, we'll be able to train our judges. We retrain to the extent that their capacities will be built, and they'll be able to resist every attempt by either the executive or any other agency from encroaching onto their territory in terms of the exercise of their judicial power. Thank you.
Thank you, and I don't have a follow-up question on this, but let me go around this question. A lot of people have asked questions about the jurisdiction of the Supreme Court. We have about 7 or so. And I know sitting on the Court of Appeal, a lot of interlocutory appeals comes to you. From there, they'll go to the Supreme Court. If the substantive matter will not be dealt with, and the public will always be complaining about it. Given the opportunity to sit on the highest court, which of these jurisdictions that the Supreme Court is closed with would you propose some reforms so that some of the matters are terminated, maybe at the High Court level, Court of Appeal levels, to also help in the reduction of the workload on the Supreme Court? And on that, Sir Dennis, I wish you the very best, and God bless you. Thank you.
Thank you, Honorable Chair.
Yes, my Lord nominee.
Honorable Chair, if you talk about the jurisdiction of the Supreme Court in Ghana, let me start with the first one, the supervisory jurisdiction. The whole world, Ghana was the first country to give supervisory jurisdiction to the Supreme Court. Sierra Leone was number 2, and Philippines number 3. Throughout the world, these are the only 3 countries where Supreme Court exercises supervisory powers. If you go to UK, you go to all other countries, it is exercised by the High Court over the lower court. Because you call a court a superior court, then you are still supervising it. You know, Ghana introduced it through the 1969 Constitution. And if you look at the cases before the Supreme Court, about 40% of them are on supervisory jurisdiction. And you know, it is very broad. It is not limited to those coming from only Court of Appeal, High Court, Regional Tribunal. You can even go from a district court, for example, where a district court is interpreting Constitution. High Court cannot say that I am supervising you, because the High Court itself has also been restrained from delving into that matter. So any area that the High Court lacks jurisdiction in, and any of the lower courts purpose to do, you have to go to the Supreme Court. So now, if you go by the supervisory jurisdiction, I believe it will be okay. But the Supreme Court introduced another limb to it, interest of justice. Because we all know that wherever you go throughout the world, supervisory jurisdiction they have faced. We talk about natural justice, we talk about patent error on the face of the record, we talk about breach of the Wensbury principles, then we talk about jurisdiction. But Ghana, we have added interest of justice. And because of that interest of justice, any freezing case, somebody will go to the Supreme Court. You will dismiss, but the person has wasted time. So that is one thing. Then when we come to Article 131, appeals to there's a problem. Appeals, we are saying that High Court, Court of Appeal, if the case starts from the High Court or Regional Tribunal, and you come to the Court of Appeal, as of right to the Supreme Court. Then, irrespective of where it starts, if the Supreme Court decides to give special leave, they will give special leave. Then the other one, when we talk about the lower court, any person who loses at the Court of Appeal, you need leave to go to the Supreme Court. So the leave and the special leaves, I believe you can do something about them. If we take away even special leave alone, then some of them, as is done in some jurisdictions, some of them terminate at the Court of Appeal, then Supreme Court will not be inundated with all these cases. And Honorable, apart from the jurisdictions that you have said, you know, apart from those Supreme Court, apart from those the Constitution has given, the Court Act has also given 2 additional jurisdictions to the Supreme Court. The first one, Section 9 of the Court Act, that when we are talking about prerogative of mercy, where it's not the one in the Constitution, this one where somebody petitions the president that please have mercy on me. This one, then when it is sent to the president may refer to the Supreme Court to hear it as an appeal or may give an advisory opinion. Then we talk about Section 100 of the Courts Act, reservation of question of law, where Court of Appeal is hearing a matter and the Court of Appeal is confronted with difficulties. Then they reserve the question to the Supreme Court to answer for them. And Supreme Court will answer before it comes back. So these are some of the jurisdictions that we can do away with. Otherwise, Supreme Court will continue to be inundated with cases. Thank you, Honorable Chair.
Thank you very much. Before I proceed to give the floor to Haja Ladi, Justice Sir Dennis, we know your background as a lecturer. So we'll plead that you are brief. We have one more judge to take. Yes. So, Haja, you have the floor.
Thank you, Chairman. Congratulations, my brother. With all intents and purposes, I just want you to explain and tell me how you would agree with the mandatory imposition of death sentence when people violate the law. Do you agree with it? Do you not agree with it? In fact, I wouldn't want the answer to be too detailed. Just.
I agree that the mandatory imposition of death sentence is wrong. If a person goes to court and the person is to be convicted to suffer death, first and foremost, we must respect life. So we must give discretion to the judge who heard the matter, either the judge to give a number of years or to impose death sentence. But if you look at the treason, high treason, and the one in the Armed Forces Act 105, once you convict the person, then mandatory imposition of death sentence. And Ghana is a signatory to the African Charter on Human and People's Rights. And Article 4 of the African Charter on Human and People's Rights provides that you must respect life. And the African Court has variously held that any decision by any country which does not give a judge discretion in the imposition of death sentence is in violation of Article 4 of the African Charter. Ghana is a signatory. That is why I am there as a judge. And we have found several of them against Tanzania. Tanzania is the worst offender. Then we have found some of them too against Benin. So if cases from Ghana happen to be there, we are going to face the same fate. We are going to lose. Thank you.
Thank you very much.
Chairman, a follow-up on your response. I'm happy to have heard from you that we are a signatory and that you are even a member who can come up against those rulings. Will you suggest you have a committee of parliament, and even you yourselves are persons, you have individuals who can make inputs to parliament that we need to adhere to what the signatory we have appended, and that we must go by the law. I don't agree with the issue of the death penalty. I, in person, that is me. So I think I want to know from you whether you would want to take it up and that we should re-look at it.
So, my Lord, this question demands yes or no answer.
Yes. Honorable Chair, what I would say is that yes, we need to outlaw those things. And I was invited by Parliament to address them in Koforidua on this issue. And I came here to present a paper. Thank you.
Honorable Haja Ladi, any further question?
No, please. Thank you.
Well, I'll then give the floor to Jerry Shai Ahmed.
My Lord, congratulations to you. My Lord, Chairman, if, with your permission, I want to place my question on the independence of the judiciary. So, reference is made to Article 125(1), that says that justice emanates from the people and shall be administered in the name of the Republic by the judiciary. which shall be independent and subject only to this Constitution. I want to situate this with 1466. In your view, do you think the judiciary is really independent?
Yes, honorable nominee.
Thank you. The first thing is that when we talk about the independence of the judiciary, the first thing that comes to mind is the exercise of judicial power. Because the Constitution itself, 125, says that not executive or legislature shall have final judicial power. So when we talk about the independence, the first premise is on the exercise of judicial power by the court. Then when it comes to 146, it comes to removal of judges. Removal of judges. If you look at it, it has provided that a petition, if it is against me, a petition shall be sent to the president. President shall forward to the Chief Justice. The Chief Justice shall make a prima facie case. So here, the question is, would that amount to encroachment on my core duty as a judge? And the answer is no. It will not impact on my core duty as a judge. But the only fear is that, the fear that people entertain is that when the committee is set up, but for the judges, it is the Chief Justice who will set up the committee, then he takes other members from elsewhere, then they fall. And once they are sitting as administrative bodies, then the law is that they are not supposed to go wrong. They must be fair and candid. Because if you look at Article 23 of the Constitution, any person discharging administrative function shall act fairly and reasonably within the law. So once you go off the law, then that means you are doing your own thing. So, well, there's likelihood that it may be compromised. There's likelihood. We are human beings. But if we take into consideration by the fact that, yes, I'm a judge, I'm sitting on this matter, and this is my role as a judge, then at the end of the day, it should be based on the evidence adduced and the available laws that you must apply, and not your own opinions. Thank you.
You have any further question?
Yes. A follow-up. Thank you very much, my lord. My lord, so if we come on the same 146 and the responses, per the responses you've given, would you think that the president having the powers to appoint and disappoint impacts on the independence of the judiciary?
The president has the power to appoint on the advice of the Judicial Council in consultation with the Council of State and prior approval of Parliament. So it is not him alone. So if the person is appointed, then when it comes to removal, the Constitution has provided for a particular procedure. And that particular procedure, it must be followed to the letter. Otherwise, it will amount to usurping the provisions of the Constitution. So once it is followed to the letter and a finding is made, we look at who are those sitting on the matter. Are they judges? Are they independent? That is the most important thing. So if they are independent-minded people, and at the end of the day, any decision that they take is premised on the evidence, I will not have any problem with it. But if at the end of the day, the decision taken is premised on any other extraneous matters, that is where I will have an issue. Thank you.
Any other question?
That's all. Thank you very much, Mr. Chair. Honorable nominee, what would you say about 1252, where citizens may exercise popular participation in the administrative of justice through the institution of public and customary tribunals and the jury and assessor systems? And this is against the background that some of us have seen that some assessors or jurors have occasionally or largely been the ones nominated to sit on a matter. And they have been consistent. So in about 15 to 20 years ago, I knew some particular workers from AMA who were always part of the system. Would you say that this is a system you'd want to have a relook at policy-wise and advise, or you think that it's a system that has to be maintained?
Thank you, Honorable Chair. Honorable Chair, I have a thesis on the role of the jurors. And I made proper investigations. For instance, we must know qualification, who qualifies. You must be 25, then under 60. Then you must be literate in English. I went to some of the areas to make investigation. Some of them could not even speak English. Then I went to some of the institutions to make inquiries. They would tell me, oh, this man is troublesome. We have sent him over there. We don't have any other person to go there. You know, we do not understand the jury system very well. Because the jury system, it is your role to your nation building. And it is peer hearing. So we want to say that there is a matter which is a very serious matter. And therefore, we want your own people to come out to say that you are guilty or you are not guilty. That is the essence of the jury trial. But if you look at the position in Ghana now, some of them are becoming professional. If you say it, they become annoyed. When I was the regional bar president for Ashanti region, I made a pronouncement and they decided to boycott because of me. When I said that some of them will become professionals and we should not entertain, we should make sure that when you come maximum 2 years, you must leave. Then at a point in time, even they met and appointed somebody and called the person a dean. And I said, you could not call somebody a dean because it is not an office. So we need to refine it. We need to refine it because we don't appreciate the essence of jury system. If you are a judge, you may do the summing up and you may think that they may either convict or acquit. Then they will come with a decision that you never anticipated. You know, at times, you look at it, and if the matter comes on appeal, at times they have acquitted the person, or they have convicted the person, and the matter comes on appeal, and you look at it, there was no justification for the decision taken by the jurors, but it has been taken. But Ghana, the only advantage we have is that we can appeal against the summing up, unlike other jurisdictions where decisions by jurors are final and not appealable. So still, I would say that we need to reform it because as it is now, it doesn't help. Thank you.
Any question?
Yes.
Your last question?
Yes. No, this is a follow-up on the jury bit. It's not my last question yet. Apart from the suggestions you have made, is it the case that we should still have the jury system?
Thank you. We may continue to have it because it talks about citizens' participation, for them to understand the role of the judges, the role of the citizenry. Because once you become a juror, we call you a judge of facts. So you are a judge, except that you are going to determine on questions of facts. So it helps people to even appreciate the legal system. So when something happens on the street, they will not take the law into their own hands and delve into instant justice. That is the essence of part of jury system. But if you look at the African continent, most of them do not have jury system. Nigeria abolished it through coup d'etat in the 60s. They don't have. Côte d'Ivoire hasn't got. Most of them do not have. So if an empirical evidence may be obtained and we see that it has outlived its relevance, we can outlaw it. Even though ADR was not specifically mentioned, we have positioned ADR under Article 125(2). That is why alternative dispute resolution, we get people who are not judges. We have mediators, conciliators, customary arbitrators. All of them come in to help. That is the rationale. Thank you.
Now your last question.
Yes, thank you very much. So, my last question, Chairman, with your permission, Article 15(1) says that the dignity of all persons shall be invaluable. I want to look at 15(1)(b). That says that any other condition that detracts or is likely to detract from his dignity and worth as a human being. And I'm placing this with reference to, I'm situating it with reference to where a suspect now gets some details published by the prosecution, and in a very open manner, maybe through a press conference, and the person gets tortured and gets very demeaned. I do not know if you would have a take, you have any advice. Would you think that is the way to go in criminal jurisprudence? Thank you.
Thank you, Honorable Chair. Honorable Chair, what amounts to human dignity, degrading, inhuman treatment, they have been discussed in all the international instruments, particularly the African Court. I can cite about 20 cases. One of them is about where you use a cane, corporal punishment, Kabalabala versus Tanzania. It has been held that if you use a corporal punishment cane to whip somebody, you subject the person to inhuman or degrading treatment. Then torture, when somebody is alleged to have committed an offense, you assault the person, you will not give the person food, the person is hungry and thirsty, and you ask the person to give statement. It is inhuman. Then we have also held that if you impose death sentence on somebody and you prescribe that either to be killed by hanging, to be killed by a gun, to be killed by lethal injection, all of them, they are inhuman. Why do you say that a human being should be killed, a human being should be hanged? So if you look at our Article 15, it is from Article 4 of the African Charter on Human and People's Rights, verbatim. So the essence is that every accused person must be presumed to be innocent until either he pleads guilty or the court proves the person guilty. Until that one, then the person should be innocent and the person should not be subjected to any inhuman, degrading, torture, or any barbaric conduct. Thank you, Honorable Chair.
Yes, a supplementary question?
Yes.
Very well.
So, my Lord, so where we have instances of a press conference intimating that someone has virtually stolen or has virtually committed an offense or omission, I was requesting from your Lordship, respectfully, whether your Lordship would advise if that is the way to go or that is not the way to go.
The person is innocent. Whether you saw the person committing the crime or not, he's innocent because he has not pleaded guilty and the court has not convicted that person. So to me, to say that this person has been convicted, because the person has not been convicted, that is why in criminal law, we pass through stages. We pass through suspects. You are suspected. Then you are accused. Then you are charged before the court. If you are charged before the court and you go through the trial and you are convicted, then you become a convict. So convicts' rights are different from suspect rights, and they're also different from accused person's rights. So you may say that the person is alleged to have done A, B, C, D, but you cannot conclusively say that the person has done it because there is no conviction to that effect. Thank you.
Thank you very much.
Right. I'll proceed to give the floor
Chairman,
to
thank you.
Honorable Bid Awantanzuma Zidi.
Thank you very much, Mr. Chairman. On a lighter note, Mr. Chairman, I want to congratulate my Lord, Sir Dennis. But I'm curious. Since I have known you, I have not known you to have Dominic as part of your name. So I'm curious. I've always known you as Dennis, and I know you to be Catholic. We worship together. when I saw your CV, I saw Dominic. How come you have got two Christian names, Dennis and Dominic? I'm interested.
Is that your question?
I said, oh, on a lighter note.
Why on a lighter note? Is there any law that prevents a person from having two Christian names?
Yes. Come again.
Is there any law that prevents a person from having two or three Christian names?
I just say that I'm curious.
Very well. Yes. Proceed to ask your question.
Yes. Thank you, Honorable Chair. Catholics, we look up to the saints to imitate them. So at birth, I was given the Christian name Dennis Dominic. So I came to meet it. It wasn't that I took it. And I love the two names. Thank you. Because they have significance in the Catholic Church. Thank you.
Well, I'll treat that as question number 1. Go ahead and ask the second question.
Mr. Chairman, I told you that it's on a lighter note. Anyway, I've come to my main question.
Ask the second question.
My Lord, we have had some challenges. We have had some challenges here in Parliament in dealing with the doctrine of separation of powers. I want you to give us some, if you like, since you have been lecturing, a little lecture of the doctrine of separation of powers in the context of the Constitution of Ghana. And in particular, my Lord, the legislature and the judiciary arms of government. Under the 1982 Constitution, it is quite clear that the judicial power is exercised by the judiciary exclusively. That is stated under Article 125. Then, in our standing orders, the power to interpret the standing orders is vested in the Speaker. My Lord.
So basically, when we talk about separation of powers, as propounded by Aristotle, his position was that each of them should be independent, but each of them should be independent in the discharge of their core functions, not ordinary functions, core functions. Judges, judicial power, legislature, lawmaking, including your debates, your proceedings, then the executive, implementation of policies. But even he referred to the executives as magistracy, but in real sense, it is the executive. So what he said was improved upon by Montesquieu. And Montesquieu said, yes, we cannot have independent, so much absolute independence. By their core functions, they should not interact. Now, from this one, then let's come to the Ghana Constitution, as you have said. If you look at the Ghana's Constitution, each of them has its core function to perform. The core function has not been given to any one of them, but by the ancillary functions, that is where others come in. So if you are debating, whatever comes up here, free speech and those things, you cannot take it to the court. But if you have a rule, and someone is saying that this rule offends this constitutional provision, the person can go to the Supreme Court. Because that one, it is about the law. And the people of Ghana has appointed the Supreme Court as the referee to guard the Constitution. That is why if there is any infraction of the Constitution or whatever, we rush to the Supreme Court. But if it is a matter that is ongoing and it is within, that is where we have the Cruz Brook doctrine. That one you cannot take it. But if it is about a law, and I think that you are saying this law should be this, and I think that it violates a constitutional provision, nothing prevents me from asking the Supreme Court to make a pronouncement on it to guide us. Because the intention is not for Supreme Court to prevent Parliament from working, but rather to enrich the work of Parliament. That you were doing this thing. This thing is a violation of this. Please don't go and do it anymore. It must be done this way. So at the end of the day, all the infractions will be addressed. Thank you.
Any further question?
My Lord, I want to still get some clarification. The point I'm making is that in Parliament, we have got standing
Honorable
orders.
Adjei, please ask question.
Oh, I want to lay a
Honorable
foundation before asking the question.
Awanta Zidin, please ask question.
My Lord, is it proper, for that matter, that a determination of that issue has been made in Parliament by the Speaker, and somebody who is dissatisfied and a member of Parliament decides that he will still take it to the Supreme Court? That's my question.
Thank you. The power to interpret the Constitution, or the power to compare any law that is made in contrary to an existing law that gives you power, or to the Constitution. The law says that go under Articles 2 and 130 of the Constitution for the Supreme Court to make an appropriate declaration. So in that sense, if the person goes, the person hasn't done any wrong thing. It is within the law. Thank you.
Thank you. Any further question? No, that should be the third question.
That will be all for now.
Thank you very much. I will then give the floor to the second Deputy Speaker to ask one question.
Thank you very much, Mr. Chairman, for indulging me. My Lord, let me also add my voice to a lot who are congratulating you. My question is, with the inundation of so many cases at the Supreme Court, can you give your position with respect to a lot of people who are advocating that we should have a separate constitutional court to deal with constitutionality and probably leave other people to also handle other cases?
Yes.
Thank you,
Lord,
Chair.
you have the floor.
Thank you, Chair. Within the context of Ghana, I would say that we should not take that jurisdiction away from the Supreme Court, except that we should ensure that we get the adequate number of judges to sit in that court. Because if you look at the Constitutional Court, let's look at South Africa. You know, South Africa, they have the Supreme Court of Appeal as the highest court, then they have the Constitutional Court. The Supreme Court of Appeal alone is made up of 25 judges. Then the Constitutional Court is made up of 11 judges. And at times, you see that the Constitutional Court will be a bit redundant. So why do you engage 11 judges to interpret only Constitution? And when the Constitution, we don't have constitutional cases, they go to work, sit in their office, and go home. So within the context of Ghana, that jurisdiction has been given to the Supreme Court. I think we should allow Supreme Court to exercise that jurisdiction. But the only thing is that in constitutional matters, other things being equal, we can use 7, 9, or 11 judges of the court to sit, as we do in the African court. Every case, every judge will sit, unless it affects your country. In that sense, you get the blend of judges with their opinions. Thank you, Chair.
Yes, I give the floor to Honorable Deputy Rankin.
Thank you very much, Honorable Chair. Honorable my Lord nominee.
What did you say?
I said, my Lord, the nominee. Oh, okay. I'd like to find out from you. You've really given us a lecture today, and I know you have a very wide span of knowledge on certain issues. But what has been your record on contributions in advancing children's rights and gender equality within the legal framework? Thank you.
Thank you, Honorable Chair. When it comes to children's rights, I've delivered several lectures on the continent, and Ghana, I've delivered several of them. Then, when we come to gender equality, gender inequality, I have published a lot on those areas. the most important thing that we must do is that we talk about human rights. Human rights encompasses bringing all people at par. So you should not sit down for one to be disadvantaged, including children. That is why at a point in time, when people were talking about the fact that defilement should come within the pre-bargaining, I am one of those who objected to it, because we are talking about people under 16 who have been defied by people. And we are saying that if the person can pay money, the person can negotiate and pay money, then the person can be given any form of sentence. When the law has prescribed that the minimum is 7 and the maximum is 25. So I've championed a lot. And if you look at my contemporary criminal law, I've discussed a lot on children's rights, who is a child, what are the rights available to them, a juvenile, where do they go. I've also discussed them in my criminal procedure textbook. So I've done a lot of work on inequalities, to how to balance inequalities to ensure that men and women, we are at par, and children too are protected because they are young. Thank you.
To follow up, so if I understand you very well, if a revised bill criminalizing child marriage and witchcraft accusation is passed, how receptive would you be to its implementation from a judicial standpoint? Thank you.
Thank you, Honorable Chair. Honorable Chair, why should we at this modern age talk about witchcraft? It has become outmoded. And the only country that I've seen it in their statute is Tanzania. And whenever it comes before the African court, we condemn them. We find them to be in violation of it. Then we talk about child marriage. Why can't we wait for the child to get education, to learn trade, so that in future, even if there is dissolution of marriage, the child can survive? Now the person is 14, 15. That is why I'm happy with the laws on the defilement. Because defilement, it is neutral, whether male or female, it is immaterial. Once you have sex with a person under 16 years, with or without consent, you commit it. But there is a gap between our law. So if you are of 16, that means the person is 16 and the person voluntarily have sex. That one, you cannot blame any of the parties. But the person cannot marry until the person attains 18. So at 16, you can have sex, but until 18, you cannot marry. What happens within that period, the gap? I believe in future we can fill that gap. If you cannot marry, don't have sex. So why can't we make it straightforward, 18 years? I think these are the things that we need to address. Thank you.
Thank you very much, Honorable, my Lord. We passed the affirmative action bill last year, July, and since you have been a trainer, or you have been in the institution of the judiciary institution, I want to tease out your view on how you can, what do you think we should do to ensure gender parity in the judiciary? Thank you.
Thank you, Honorable Chair. The Judicial Training Institute has capacity to train the judges. But when it comes to the training, at times we are confronted with facility cash. That is the problem that we need. Because if you ask one judge to move from Kumasi to Accra for training, the person will come with the driver. The person will come with bodyguard. How do you accommodate them? It is the cost of the judiciary. But at times, the judiciary hasn't got enough budget to undertake these things. That is why at times you see donors coming in to help. But some of the donors too, their donation, to me personally, when I was the director judicial training, I rejected some of them. They will go to the CJ. Because why should you come and tell me to train judges on a law that exists in your country and it doesn't exist in my country? I will not train. So these are the important things that, so if judiciary submit budget and the training component, I will plead with budget, I will plead with Parliament that the training budget always preserve it for us so that we can get enough money to train our judges, to build their capacity so that they will be up to the task. Thank you.
Honorable Chair, let me take my lord into the current trending global issues. Looking at climate litigation, such as, and let's look at the issue of Etiwa Forest, as the case has been limited in Ghana due to the lack of specific legislation. Would you support a right-based approach to environmental cases? And how would you balance economic interest with constitutional protection? Thank you.
When we look at our constitution, there are two provisions which talk about protection of the environment. You will find it in Article 36. Then we also find it in Article 41. That is the rights and duties of every citizen. And every citizen is required to help to protect the environment. It is a constitutional duty. Despite the fact that it falls within the directive principles of state policy, it is a positive action directing every person, every Ghanaian, every person in Ghana to help protect the environment. How do we protect the environment? There are enough laws, even though we complain that there are not laws. There are enough laws. What are they? Those in the Atiwa Forest, what is the rationale? Who has asked them to go there? Do they have license to go and mine? They are illegal miners, and we have strong laws that will deal with them ruthlessly. So we have enough laws, but what to me is remaining is about enforcement. We must enforce it. Those in the Atiwa Forest, they cannot fight the entire Ghana army. They cannot fight the entire Ghana police. Why can't they arrest them? If they arrest them and they bring them to court, they are dealt with, and they are sentenced to a number of years as prescribed. Here we are talking about deterrent and preventive. We achieve some of the theories in criminal law. So, Honorable Chair, what I will say is that yes, we need to fight it, and it is corrective effort, because the law does not say that only police should fight. It says that every person shall contribute to the protection of environment in Ghana. Thank you.
My last question, Honorable Chair. What 3 specific constitutional amendments would you recommend to modernize Ghana's succession framework? And if I may ask, for each of them, if you can explain the current problem and your proposed solution. Thank you very much.
Thank you, Honorable Chair. Honorable Chair, my first proposal will be the district assembly. That the position now, we are saying that it should be non-partisan, but on the ground, it is partisan. Why can't we be bold to say that this is what initially we intended to achieve, but it cannot be achieved, and therefore, you can go partisan way, because that may help, because as it is now, we are saying that it should be non-partisan, but every assembly member, they will tell you that this one belongs to this party, this one belongs to this party. So that is my first one. And the second one concerns my own work as a judge. Judges sitting in court as additional judges. That one should be abolished. Judges sitting in court as additional, because it is not done in any country. It is not done in any country. We have enough high court judges. Why is it that if there is a case to be tried by a high court judge, we ask a court of appeal judge to go and sit? We have enough circuit court judges. Why is it that if there is a case before the circuit, we ask a high court judge to go and sit as additional? You know, that one we are talking about human influence. And we must reduce it. We must curb it. I have examined almost all the constitutions in Africa, and I haven't seen in any country where they ask judges to go and sit in another court as additional. So if we do away with that one, because always when a judge from a higher court goes down to sit on a matter, the impression is that why can't we get a judge from that court, but we bring a judge from another court? So even the mindset alone, it speaks volume. They start talking about bias, whereas we have enough judges for the same court. So to me, that one should be abolished. It is my own opinion because of the constitutional analysis that I've made. I think it should be abolished. So having said about these two, I think it is enough. Thank you.
Thank you very much. I wish you the best of luck. Thank you.
Thank you. I'll proceed to give the floor to Honorable George Kweku Ricket Hagan, the Vice Chairman of the committee.
Thank you very much. Sir Dennis or Lord Dennis, I'm sure each of them will go. Congratulations. My question will be an expansion of the question that Mr. Speaker, and that is second Deputy Speaker, asked. And he was looking at whether there should be some additional courts, to deal with constitutional courts to deal with issues. But I want to look at the entire court system or the entire judicial system. There are a lot of complaints that there are a lot of cases building up in our courts, and that some of the reasons is that we don't have the manpower to do the work, or there are some inefficiencies that need to be worked on. There's another school of thought that thinks that we should automate our courts fully, or at least to a greater extent. And that is to bring in that the functions of the court were mainly based on some kind of a database systems and management to be able to move things much quicker, in the court. We do say that the wheels of justice grind slowly, but it looks as if things are grinding much more slower than they should. In your view, would you also share that view that we need to automate our courts or computerize our court systems to become efficient enough to move cases much faster than they are being channeled at the moment? Thank you.
Thank you, Chair. The court has passed through several stages to ensure early disposal of cases. We started with the scopists, that they will move fast. Then at a point in time, we saw that the scopist work was not also moving. So we moved to the next level. The next level was to promote automation. Automation, at times, staff will be working and the light will go off. The court becomes a standstill. Now, the aim of the judiciary is to achieve the e-justice. And the e-justice, you cannot achieve the e-justice where you do not have dependable internet. Because number one, e-justice, we start with e-portal. Go to the website, you'll find everything that you need. Then after e-portal, then you move on to the second one, e-forms. When you need the forms, you just go and print. Then e-filing, you use the same form to file. Then after e-filing, e-case distribution. There will be no manual for the head of the institution to say that you judge, go and sit on this one, you judge, go and sit on this one. It should be automatic distribution. But we do not have all these things. Then after that one, then we move on to evidence. We take evidence, then we do electronic hearing. Then we move on to electronic judgment. We've been talking about justice, the E8. As at now, to me, I don't think we have even achieved 2. So we need money to overhaul the digital system of the judiciary to enable us to use the equipment to dispose of cases expeditiously. Otherwise, manual, if you go to some places, you see handwriting. It takes some time. Then at times, apart from the handwriting, you get interpreters. All these contribute. So I think that it is the wish of every judge that the court will be fully equipped with the E8. When we have, it becomes even a joy for you to work under such circumstances. Because if you come to the African court, for instance, and we are working very, very fast, the number of decisions, even though apart from the president, the 10 judges are part-time. If I tell you that 1 year, we can deliver about 36 judgments within 4 months. So it is the wish. And I will still plead that Parliament, when we present our budget, please defend for us, don't cut, so that we can help to promote expeditious disposal of cases. Thank you.
Any further question?
Yes, Mr. Chairman, one more question. And this one is actually on a lighter note. I'm a bit curious about this. You realize that most of our courts, the ones that I've seen and ones that others have been, again, you did talk about energy, of course, power issue. But we tend to have, a lot of our courts don't actually have air conditioning or AC and these things. Where we have them, they don't work. But then we continue to wear our gowns and our wigs. So I'm wondering, I know it's a colonial legacy that the institutions like the judiciary got seriously. But you realize that the Speaker has taken off his coat, and so are the other, the first and second speakers, and including the clerks. Don't you think the gowns, though they are legacies that maybe we treasure, it's a bit outmoded, that we should maybe start putting on our traditional stuff like the Speaker and others are doing? These things will be much more practical, or these clothing will be much more practical for our kind of climate than the colonial gowns that we continue to put on, and probably use them on ceremonial basis like we do in Parliament today. Thank you.
Thank you, Honorable Chair. Honorable Chair, the wig and the gowns, they have several significance. They have several significance. Now, was it 2012, 2013, 2014? There was a proposal that we should not be wearing wigs and others. And we found, in addition to what I'm going to say, we found that some people who were not lawyers were posing as lawyers. Because it's just a matter of getting this and tie. You can go to any court, announce yourself, I'm Dennis Adjei, appearing for this one. But if you talk about Parliament, Parliament is just one. Speaker is just one. So I'm happy that Parliament has taken the bold decision. But for the judiciary, wherever you go, every court has its own robe. All the international courts, all the national courts. So to me, my policy is that, after all, it doesn't take away anything from us. It doesn't take away anything from us. What it does is that it sets you apart, that this is a judge. Look at with its wig and gown. So to me, I treasure it. So, Honorable, I will not support your position. Thank you.
Thank you very much. I think that we need to repair the air conditioning.
Honourable members, lawyers who are wearing the wig in Ghana are not complaining, but non-lawyers are complaining. Is it because they have no opportunity of wearing them?
We see you sweating.
Yes, it's now the turn of Osahin, Togbi Osahin Alexander Kwamina Afanyo Markins, the ranking member of the committee. You have the floor.
Lord, in 2023, did you do part-time teaching alongside your judicial duties?
Yes, please. Whenever I'm in Ghana, the law school, I teach. Initially, I used to teach the entire part too.
My Lord, I would crave your indulgence to give me direct answers. So I repeat, my Lord, in 2023, did you do part-time teaching in Ghana?
Yes, please.
In 2024, did you do part-time teaching in Ghana?
Yes, please.
Please, in 2023, the part-time teaching you engaged in, were you remunerated?
Yes, please. But if I tell you some of them, you will laugh.
Oh, don't worry.
Yes.
What about 2024?
Yes, please.
I have with me a GRA tax clearance certificate you brought to us. Your TIN number GHA 711947735/0. It bears the name Dennis Dominic Adjei. And the purpose, it says year of assessment 2025, and purpose, to support my nomination to the position of Justice of the Supreme Court. I would like to know from you, by the way, do you have a copy of that tax clearance certificate with you?
I may have the sir.
May the clerks supply the nominee with a hard copy of what he has furnished the committee, please. My Lord, please, are you in possession of a copy of your...
Yes, please, I am.
Very well. Now, in obtaining this tax clearance certificate, I want to know from you whether you did the computation of your tax obligations yourself, or that you relied on the finance department of the judicial service for them to forward your details to GRA for the purpose of obtaining this.
Thank you. I forward to the finance division of the judicial service, and they know all the schools that I teach. So they take all of them into account, and they tell me that whenever it is paid, they take the how do you even call it, the VAT and others from it. So this one was obtained this year, but every year I do that. Thank you.
My Lord, you went ahead to answer a question I've not asked. So that's why I said, please bear with me and let's be on the same page, point by point, so that there will be clarity, you know. So you forwarded your details to them, the finance department of the judicial service.
Yes, please.
So, regarding whatever computation they did with GRA, you were not privy to it.
After it is prepared, they bring it to me for my signature, and I sign.
Now, when they brought the document to you for you to sign, did you really pay attention to the details they had computed, or you assume that as professionals they've done the needful?
I presumed that the writing has been done.
All right. My Lord, that being the case, I will want to strongly suggest to you to get back to them so that they add your other remuneration from my checks. What they sent was your salary, what you directly earn from the judicial service. So, in other words, the tax certificate we have here does not constitute a full disclosure of your tax obligation. So I'll give you the opportunity to get back to them and urge them to do the full disclosure as you provided them. Is that okay by you?
Yes, Honorable, it's okay.
All right. So, my Lord, you agree with me that the presumption of regularity on their part really could have cost you some challenge here because they have not fully disclosed, and you also have the certificate bearing your name, correct?
Honorable, thank you. Honorable, I tell them to prepare, and for my house, the rent, I pay the rent tax myself, and that one, they disaggregate from this one. That is why I did not cross-check whether it has appeared on that one, so thank you.
Yeah, but you don't have a separate tax certificate regarding your rent tax or whatever you're talking about. I'm talking about your earnings. So you may go back to them if you want to assure this committee that you will do that needful. The records would permit you, and with the leave of the chair, so that we don't drag this.
Thank you, Honorable. I can do it. Even tomorrow, I can go there.
Yeah, what I'm saying that you have to, procedurally, yes. I don't have the powers. The chair must grant you the leave. So then I would not pursue this with assurance given with the leave of the chair.
Honourable members, the witness or the nominee is telling us that he's been paying the rent component of the earning directly. And normally, the GRA will consider matters as a whole in issuing the tax clearance certificate. So if you have any specific reason to doubt the tax clearance certificate that is here, you may say so. Then I can then use my discretion to decide whether to grant leave or not to grant leave.
Honorable, if leave is granted, I will be happy so that I will get it. If there's the need for me to incorporate that one, I will not have any problem.
Leave is hereby granted.
Honorable nominee, let's do some little exercise on your CV. Page 8 of your CV. On page 8 of your CV, you have honorary position. And you state, quote, knighted by His Holiness Pope Benedict to the Order of St. Gregory the Great on the 18th of October, 2005. I presume that it is this honorary position that your title, Sir Kamet, correct?
That is so. It goes with title.
Very well. So, this Order of St. Gregory, is it a fraternal society within the Catholic Church?
No, priest. It depends on the services that you have rendered. They look at 3 things: your contribution to your country, your contribution to humanity, and your contribution to the church. Then they make recommendation to Rome for Pope to consider. So if the Pope deems it fit, then the Pope may knight you into any of the categories. Thank you.
When you say any of the categories, what exactly do you mean?
We have the Equestrian Order. We have St. Gregory the Great. We have St. Sylvester. We have multiples of them.
But in Ghana here, your journey in Christianity within the Catholic Church, do you belong to any of the fraternal orders in the Catholic Church of Ghana?
That is so. I'm a member of Knights of St. John International.
Now, you would agree with me that a person who is a Catholic and not a member of that lodge is not admitted into its assembly and its practices. You'd agree with me?
About thank you, Catholic Church. We don't have lodges. We have the Knights, either Knights of
The
Marshall.
fraternal order, correct? It's a fraternity.
It is a Catholic fraternal
That's
order.
what I'm saying.
Yes, please.
I'm not saying anything outside of it. We are in the Catholic Church. I'm not talking about anything outside of the Catholic Church. So,
Honorable ranking member,
about his CV.
just calm down. The witness is telling you in the Catholic Church they don't have a lodge, they have knights. So please take the answer.
Chairman, honorable nominee, you would agree with me that those who do not belong to that fraternal society in the Catholic Church and do not know your practices and your value system often criticize what they don't know. You agree with me on that?
That is so.
And for your lifetime, would you confirm to this committee that you've come across such criticisms of such nature? You would agree with me?
That is so. At a point in time, somebody died. We went to bury him. We went to bury the person. They thought we were coming to resurrect the body. I saw them lying. So I invited all of them to come because at that time, I was the Grand President. So I said they should allow them to come and observe. We are there just to pray for the disease. That is all.
Honorable nominee, if you say you are praying for the disease, but the priest, I believe that the priest had already prayed and performed those burial rites. So your fraternal group would also do further praying?
That is so. We don't have limit to prayers. If I get even 1 million people praying for me, I'll be happy. So that is why even our deceased brothers and sisters, we continue to pray for them. And we have a day that we remember them. We call it memorial service, to remember and pray for them.
Honorable nominee, let's go back to page 2 of your CV, please. Please clarify for me. What certificate do you have for your first degree?
Bachelor of Arts, Law and Linguistics.
would I be wrong to say that it has that law and linguistics, Bachelor of Arts, law and linguistics, has the same value as LLB? Would I be wrong to say that?
They had equal admission to the law school. So I would.
Now, clarify for me again. You have stated qualifying certificate in law, and you indicate 1991 to 1993. If my math is correct, that's 2 years, correct?
That is so.
For what I know, this Makola Ghana School of Law, the professional law, is 2 years, part 1 and part 2. Is that what you are describing here?
That is so.
So do I take it that having attained BA, Law and Linguistics, you were given an exemption not to pursue any LLB or do what they call the qualifying certificates in law prior to doing the professional? Because just by way of background, when you don't do LLB and you do BA, you would have to get in to do a post law degree program before you do the professional. I want the clarification. I don't know whether during your time the situation was different.
I don't know, but during my time the situation was different. Number 1 to 60, LLB and BA, all of you will go to the law school. There wasn't any distinction that because this one has done this, you need to do this. And it was 2 years.
No, I want some clarification again, please. Help me. So, your time, we had mainstream LLB students at the faculty, right? Who pursued the LLB. And from what you are saying, those of you who did BA, law and any other discipline, linguistics, psychology, etc. If you say 1 to 60, what exactly do you mean?
When you go to the first year, the entrance, the exam that we did at the end of the year, they will take 90 students during my time. They will take 90 students. Then the first 1 to 40, they will do LLB. 41 to 60 will do BL. All of them will go to the law school. 61 to 90, they ask them to do the 2 other subjects that they did.
Okay, so in other words, those of you who did B, though not strict LLB, were added to still pursue the professional law. That's the point.
Yes, it was a matter of course.
Okay, very well. Now, Honorable Nominee, if you eventually get confirmed, how many years are you going to be on the bench to retire?
Close to 9 years.
In other jurisdictions, specifically the American Federal Supreme Court, there is no such retirement until death or resignation. There is this call for us to amend our constitution to extend the retirement age of Supreme Court judges. What is your own view on that?
Thank you, Honorable Chair. Honorable Chair, the U.S. system is a bit different. When you are of 65, you can take a senior judge status. So in that sense, you may decide to sit either 1/3 or half of your volume of work. They have senior judge status. And if you become 80 and 90, the number of cases that you will sit on, you decide. You decide, and it is given to you. That it is for the whole federal court, from the district court, circuit court, and the Supreme Court. You know, they call their high court district court. So district court, circuit court, and the Supreme Court. They call it appointment for life. But Honorable Chair, just 2009, the UK, they have increased the retirement age of their Supreme Court judges to 75. But for me, I think in Ghana, the 70 is okay. Because people go home within 2 years, they die. Because of the volume of work that we do. Thank you.
My Lord Adjei, you have made a very profound statement this afternoon in response to a question regarding judicial precedents, judicial decisions. And you made reference to this end-all concept where, according to your explanation, because of the judicial position taken by the presiding judge in a particular matter, the all was defined in a certain manner. And later when he retired and the end group also took over, that one was stated to be the old law, and the new one was to take precedence. I agree with that. That's the general position of the law. Now, until 6th of May or so, the general belief was that when an injunction application is filed, once a party in that litigation is served, it operates as a stay until the matter is dispensed with. But my Lord Kulindi, in the recent 3-2 decision in the matter of Kowasifwa, has put that matter to a peaceful rest, to the effect that there must be an express order from the court. And it is that express order that can restrain a constitutional body or statutory body from acting in a certain way. Would you be of this new school of thought, or you remain with the old position of the law? I want to know, you are an academic. Let me hear from you.
Thank you, Honorable Chair. Honorable Chair, there are two positions at common law. At common law, one of the schools will hold that if the application is filed and it has not been granted, it does not constitute injunction and contempt cannot be founded on it. Then the second school is saying that if an application is filed against an act to be done and it is filed timeously, then the person must hold on and wait for the outcome. So there are two positions. So if Supreme Court has taken one of them, then that has become the position in Ghana, because there were two unsettled positions.
So now, express injunction is a rule. Mere filing and service is not, because, my Lord, now, I said this because in the Ablekuma case, the Ablekuma, the Honorable Minister of Interior, when he was invited to appear before Parliament to explain why the security had failed to provide assistance to EC to enable them to complete, his answer was to the effect that the security services, fortified by the court's pronouncement, to the effect that once they have been served, they have to hold on. So he justified the point that because a party in that EC collation process had filed a process in court, they felt injuncted because they said they've been served. So EC itself was injuncted, although there was no express injunction, just the service of the process. So I would want to find out from you, you are going to the bench. How do you reconcile? Because these are two issues, and they all have national significance.
Honorable Minority Leader, with all due respect, the nominee is seeking for your approval in order to go to the Supreme Court. He is not yet a Supreme Court judge. We cannot get him to constitute himself into a Supreme Court judge to be commenting on these matters. Two, by your narration, you indicated clearly that the matter is before the court, and somebody feels that I have been injuncted by the mere filing of the injunction application. Who knows that if you give him the nod, he may be one of the judges who will have to sit on a contempt issue. So getting him to make comment at this particular level, I feel strongly is outside the scope of questions that we should be asking the nominee. So I humbly plead that we move from that line of questioning to any other area.
My Lord, I've heard my chair. I want to give my chairman the benefit of doubt that maybe I didn't situate my question properly for him to appreciate it. But the whole exercise here is to hear your views on matters of law and national importance, public policy matters. And we are not asking you to make a judicial pronouncement. That is the point here. So I don't get it, but I would frame it differently. My Lord, the Ablekuma North Declaration, according to the records of Parliament coming from the Minister of Interior, the Ghana Police Service is unable to provide security because of the presumption that a party has filed a process at the Supreme Court. And to the extent that that process has been served on EC, the security services have been advised that it operates as a stay. Hence, they are not providing security until the matter has been determined. My question to you is that, what is your own view on this presumption in the light of the Eko Asifua case, where the majority of the court, speaking through the respected Justice Johnny Kulendi, stated that it must only be an express court injunction to create that estoppel, rather than relying on a mere filing of the process.
Thank you, Honorable. Honorable, you have even stated that Supreme Court has decided. And when Supreme Court has decided, whom am I, an ant, to say that Supreme Court has said this, it should be this. So once there's a definitive pronouncement by the Supreme Court, then it is binding on all of us until it is varied. Thank you, Honorable.
Thank you, Mr. Chair. Mr. Chair, what I want to know from nominee is that as a jurist himself, and fortunately, you are of the academia stock on top of your work. I'm not talking about the estoppel imposed as a result of the judicial pronouncement. Here, we are discussing opinions and views. Okay? You are not sitting as a Supreme Court judge. In fact, even if you go, if you are confirmed and you are there, you are presiding on a matter, you would have the opportunity to express a view, whether you agree or disagree with that position of the law. You may be in minority or still join the majority. What I want to know from you is that the idea that filing and serving on a party, do you hold the view that it should operate as a stay in the absence of an express judicial order?
Honorable Minority Leader, with all due respect, the nominee has stated clearly that once the Supreme Court has made pronouncement on the matter, who is he? Significant of the fact that he doesn't want to comment on matters that the Supreme Court has made pronouncement on. So let's make progress, I beg you.
Chairman, with respect, we've had a beautiful day. I expect you and I to appreciate the angles we take on the matters. I have understood him. He says he doesn't want to go there, and I have understood him. I agree. Now, I put the question differently, that at this point, I am soliciting his view on a matter. I'm not saying that he should go and criticize his colleagues who are there. I'm not saying that. Neither am I saying that he should sit here and overturn a judgment. I disagreed with the position of the majority. But in my recent review application on the House floor, I quoted it copiously because I'm bound. That is the law. And that is what I use in my review application to challenge your earlier ruling sustaining the preliminary legal objection of Honorable Ayerga against my motion on sub judice. I quoted, I relied. The cameras were there. The records of Parliament will bear me out. I am bound, and I agree with you. But it is not that path we are taking. I am asking that as a judge, as someone who teaches the law, what is your view on these schools of thought? Do you believe that there could be some exceptional circumstances where service of the process must operate as a stay and not to wait for express judicial order to restrain the person? I just want to know your view, but not to attack
With all due respect, the nominee was clear in the answer provided that once the Supreme Court has made pronouncement, the word he uses, who am I? So the Supreme Court has stated clearly what is his opinion as compared to the judgment delivered by the Supreme Court. Let us be very careful so that we don't constitute the nominee's vetting to sit as a court to either review the decision of the Supreme Court or comment otherwise on the decision of the Supreme Court. That is where we have to be very careful. That is what I am drawing your attention to.
Mr. Chairman, the whom am I phrase he used was in respect of he having the power to overturn that. We are not in that space. That is not where I am. The subsequent question that I framed was in respect of an opinion in respect of the two schools of thought on this subject matter, not for him to attack the judgment. And I agree perfectly. That's not where I'm going. The gravamen of my question is, where do you stand in the two schools of thought? If I have to clarify, where do you stand in the two schools of thought?
Honorable, depending on the nature of the case, then that will influence my opinion. For example, if Parliament is sitting and somebody is bringing an injunction against Parliament from discharging its constitutional mandate, I will not say that the fact that it has been served, it constitutes an injunction and Parliament shall not sit. We are coming to have national elections. Then you rush to EC, serve EC, don't conduct presidential election. Then EC says, I'm not going to conduct by the service of the application. That's when it will create anarchy. So even the two schools of thought, we need to treat it case by case basis. Thank you.
My Lord, may we, I'm happy with this. It's a matter of case by case. It's not a rigid thing where you say there's an absolute position and all. And I'm satisfied. Thank you. My Lord, may we do a little exercise on Article 1442? My Lord, does my Lord have his constitution by him?
I've been given one.
And you have the 1442. You are there with. My Lord, if you may read that aloud for us.
The other Supreme Court justices shall be appointed by the President acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. Thank you.
Okay. My Lord, I'm going to give you two practical examples, and I would put my question for you to express a view. So I claim your attention. First, I shall refer you to a letter dated 30th of May, 2024, written by Her Ladyship, the Honorable Chief Justice, Araba Isaba Tokonu, and the letter is addressed to a right to respectfully request that the following judges be appointed to Supreme Court of Ghana. Now, this letter from the Honorable, I have two. You want it? Oh, okay. I thought it would be a waste of time, but Chair direct that I read the document as a whole, which I will do, don't worry. So I would now go over. I write to respectfully request that the following judges be appointed to the Supreme Court of Ghana. 1. Her Ladyship Justice Angelina Mensah Homia, J. His Lordship Justice Eric Cheba for J. His Lordship Justice Edward Amwakwa Santi, J. Her Ladyship Justice Sarah Pamela C. A. Kranti, J. Her Ladyship Justice Ifia Sewa Ifia Asaribotwe, J. Then goes on. Justice Asante's term of office at the ECOWAS Court ended on the 31st July 2022. He was requested to remain at post on account of the withdrawal of Mali, Guinea, and Burkina Faso from the community. His current tenure is expected to end in 2026 or earlier, where he is expected to return to Ghana's judiciary. Now, this letter was publicly construed to mean that the Chief Justice was interfering with the powers of the president as contained in the Constitution, and received a lot of criticism. 1. 2, the general practice that we've known when it comes to nominations to the Supreme Court has been that nominations come from various stakeholders in the legal fraternity. And on the basis of that, the Judicial Council does deliberations on these nominations and makes a recommendation to the president for the final decision of appointment. Now, in the recent appointment of 7, of which you are included, there was a single letter that emanated from the presidency directly to the Judicial Council, which letter directly effected the appointment and urged upon the Judicial Council to advise. My Lord, with these 2 scenarios given you, I want to ask you, within the context of the provision in 1442, which you've already read, and at the risk of being repetitive, I would go over, that other Supreme Court justices shall be appointed by the President, acting on the advice of Judicial Council, in consultation with the Council of State, and with the approval of Parliament. How do you place on the advice of the Judicial Council? Is it the case that they will nominate for final appointment as was contained in the decision of the Supreme Court in the matter of Ghana Bar Association against the Attorney General, when my Lord Mafusao, my Lord Apau, and my Lord Puaman were eventually appointed out of the 4 recommendations made to the presidency and in a certain order. And the Ghana Bar Association took issue with the presidency that, look, Judicial Council made a certain recommendation in an order of merit. And it was Mensa Bonsu, Mafusao, Apau, and Puaman. But the president took from the bottom 2. How do you reconcile all these scenarios within the context of, upon the advice of the Judicial Council? What is the function of the Judicial Council in this whole process, in your view?
So
thank you.
My Lord, from all that you have said, what really is the question? The functions of the Judicial Council in appointment of judges, is that it? No, Minority Leader. Is that the question? Yes. Very well. Proceed to answer.
Honorable Chair, I know about the case because at that time I was the president for Association of Magistrates and Judges of Ghana, so I know much about that case. What happened in that case is that the president brought 7 names to be considered. Then the Judicial Council added 2 names. Then the bar brought 2 names. And the the Judicial Council conducted interview, and at the end of the day, they concluded that their nominees had been number 1 and number 2. And the one brought by the president, 3 and 4, and the others have failed. Once he has gotten Justice Yawape Employment out of them, he will swear them because he has not nominated them. The law says he should nominate. So, Nena Megache, then Nena Megache, now Justice Nena Megache, Justice Amenuvo, and Mr. Frank Beecham, they brought an action against the Attorney General. And the Supreme Court, the majority decision by Justice Atuguba.
My lord was part of the case. It wasn't majority, it was unanimous.
Unanimous.
Yes.
What Justice Atuguba said was that, leading the lead opinion of the court, what he said was that every nomination must be endorsed by the president or must stem from the president. So this one, once it was not made by the president, it does not bind the president. That was the Supreme Court decision, which binds everybody. Thank you.
My lord, I do not want to have a disagreement with you on this, but maybe sometime we may have to refresh our memory. I was involved in that case because our case was consolidated, because at the time I was counsel for a plaintiff who was challenging the appointment to the EC. So we had a consolidated case. I respectfully, and I do so in all modesty, the government of that decision was to the effect that, to the extent that the Judicial Council had made a recommendation of all 4 to the president.
Honorable Minority Leader, sorry to interject. The rules are clear. When questions and asks and answer provided, you do not argue, you don't offer an opinion, and you don't address. So please, ask another question.
Chairman, let's make this exercise as interesting as possible. Let us help shape the public discourse in a very coherent manner. All that you said is not what I am doing. My lord has stated a view on a judgment that, as a lawyer, I really was part of. If I am seeking to clarify, I've not gone out of the rules. Please, you must also, please, respectfully, pay attention to my line of discourse so that you don't hurriedly rule me out of order or say I am saying something different. I am making
ask your clarification.
Sure,
question.
that's exactly what I'm doing.
Yes, ask clarification question.
Honorable Bid, please. Bid, you've had your time. Bid, please, don't do that.
You are entitled to ask a question for...
Chair is directing affairs. Please stay.
Honourable members,
stop.
You are entitled to ask a question to clarify.
You don't have a better personal relationship with my Lord Dennis Adjei than I. Stop it.
The comment,
he knows me.
the
Please,
argument,
stop
the sharing of opinion is what the rule says we cannot do regarding questions.
One is entitled to provide clarity. It also helps the discourse. My Lord, like I said earlier, the government of that decision was to the effect that, to the extent that the Judicial Council had made a recommendation of all 4, it doesn't matter the order of merit. It doesn't matter the order of merit. The president could choose from amongst the 4, whether from the bottom, in the middle, or whatever. That is it. And I remember the end phrase of my Lord Atuguba was that mutatis mutandis, the case is dismissed. And we all laughed loudly in court, and then we walked away and thanked the bench. Now, you have given some explanation to the scenarios I've given. I want to know from you specifically, what is the opinion you have on the phrase, the president acting on the advice of the Judicial Council?
Stakeholders and come out with names to be considered by the president. That is for Sierra Leone. But Ghana, this is the interpretation that we have given, and it is binding on me. Thank you, Honorable Chair.
Thank you. Yes, you have the floor.
My Lord, I want us to deal with statutory construction and executive discretion. You had earlier on talked about enactments providing some penalties. Someone was asking you about social media and all, and the press freedom. And you made it clear that some of the enactments on communication law, electronic communication makes provision for some penalties that criminalizes it, although it's still seen in the context of free speech, but it has criminalized it. Now, this one, I'm relating it to the Minerals and Mining Act and our Immigration Act. Now, when laws provide both criminal penalties and deportation powers for the same conduct, which of them would take constitutional precedence? Can the executive choose administrative remedies over legislatively prescribed criminal sanctions? In the case of a foreigner, that we will not prosecute, but we are going to exercise administrative discretion of deportation.
Honorable Chair, I don't know the context, so I will be at large. What I will say is that where the law prescribes that if the person is convicted...
Then let me limit you to help. Let me give you the specifics so that you don't have to spend a whole period. Does that work with you? Very well. So, my Lord, on this issue of illegal mining, we have citizens of Ghana who are caught, arrested, and they face prosecution. Government announced that for foreigners, they will invoke their executive powers given them under the Immigration Act to deport them. What I want to know from you is that in view of the law criminalizing the action, the conduct, can there be an administrative remedy over a legislatively prescribed criminal sanction? Can that take precedence over the criminal sanction provided for by the law merely because the person is a foreigner?
No, Honorable. But Honorable, the thing about criminal law is that the state exercises eminent power, because the state may decide, that even enter no prosecutor, don't do this. So that power, even though it may not be palatable, it may not be acceptable, once the executive has the power to control criminal proceedings, it may do it.
My Lord, do you think, from what you've just said, would you want to suggest to us that there are constitutional limits on prosecutorial discretion when statutory criminal penalties are mandatory rather than executive discretionary powers being exercised? Is that a suggestion?
Honorable Chair, what I'm saying is that the power to prosecute is vested in the Attorney General. Attorney General may decide to prosecute or not to prosecute. Somebody may be a thief. The person might have been seen holding something, but the Attorney General says, I will not prosecute you. You cannot compare Attorney General to prosecute. That is what I'm saying. But I'm not saying that whenever there is a conflict, that is how it should be resolved. If there is conflict in the law, that's why I am a legal interpreter. I can resolve it. Thank you.
Yeah, so, my Lord, the mainstay of my question, and I believe a lot of Ghanaians are concerned that we are caught in the act of illegal mining. Because I'm a citizen. AG to prosecute or not to prosecute. But I'm juxtaposing this against the idea that, well, somebody is to be prosecuted if he's a citizen, but a foreigner, we should go for deportation without prosecution. I think that's the mainstay of my question.
Honorable Chair, thank you very much. Actually, let me be honest. I don't know the circumstances that led to the deportation. That is why I don't want to commit myself. I don't know when it happened. I'm not abreast of the facts.
I can update you. I can share with you.
All right.
I can share with you. So recently the Interior Minister announced that for foreign nationals who are caught in galamsey activities, the decision of government is to the effect that instead of prosecuting them, they will be deported. It is on that basis that I am teasing out this question of where there exists prosecutorial discretion. Would we want to, at the same time, deny ourselves of that and go for an executive discretion that And you have Article 19. Would you hold the view that in the absence of due process, where the underlying conduct constitutes a criminal offense, one cannot sidestep this and move away to directly deport a person?
Honorable Minority Leader, please try and one up before 6:30 in view of the fact that we agreed to take another nominee.
Chairman, with respect, I am asking my questions. If at any point you want to stop me with the exercise of your powers as chairman, you can, and I will not protest. So I will ask my questions. I'm not done. But if you think you are the chair, you have the powers, let history record it, and we would comply with it. So let me finish my questions.
With all due respect, you have 6 more minutes. You have 6 more minutes.
Chairman, no problem.
At exactly 6:30.
Honorable nominee, given the absence of comprehensive legislation, courts have relied on equitable principles to address cohabitation disputes. What is the appropriate scope of cohabitation?
Honorable, cohabitation in respect of property acquisition, it is treated as people who have acquired properties, but not within the context of marriage. You can acquire property with a friend. You can acquire property with a girlfriend. You can acquire property with anybody. When it comes to dispute, the question is who provided the money that was used to acquire the property. It will be based, I cannot say that it is either this or that, because if there is a matter or I'm writing an opinion, that's where I can. Because just to say that on the face of it, there's no sense, I think I will not act as a professional judge. I will be acting in vacuum. Thank you.
Now let's go back to Article 144. We're talking about presidential appointment of Supreme Court justices with advice of the Council of State in consultation with the judicial, with the advice of Judicial Council and in consultation with Council of States. And of course, it follows with prior parliamentary approval. Would you want to precisely define what your understanding of consultation in this context mean?
We have 2 words here, advice and consultation. Advice has been held to be stronger than the word consultation. Advice, they must offer, even though it is not binding on you, you must. Consultation, you can just meet them and say, I have A, B, C, D. These are the CVs. What is your opinion? And if they say yes, you may go ahead.
If they say no?
The general law is that once it is either an advice or consultation, if they say no, they must justify why it is no. But if they say no, that one you cannot proceed because they are advising you against it, or you need my consent, and I'm saying that this one I will not give you consent for the appointment. Thank you.
So your view is that where it is a no, the appointor cannot proceed. That is your view.
Yes, and if reasons are assigned why you do not, why you think that I should not appoint that person. Example, if it is a personal hatred, you went to court and you had a matter before the court and the judge ruled against you. You cannot use this one as basis. Thank you.
Honourable Minority Leader, with all due respect, may you please ask your last question so that we can make progress.
Honorable nominee, Chairman, I disagree with you, but I will yield to your authority, please. Honorable nominee, the Constitution and Article 146 has provided for what is known as stated misbehavior. It permits a removal of a justice of the Supreme Court without defining the term. In your opinion, what would you consider to be stated misbehavior that would guide the exercise of such powers by the authority?
Thank you. Thank you, Chair. Chair, even though you say that the Constitution is sui generis, and therefore it is not advisable to borrow elsewhere, where you can interpret it within the context of the local materials. But in some cases, you may need inspiration from other countries. There are several jurisdictions that the word misstated misconduct have been established. So you may look at some of them and you allow yourself to be persuaded within the context of this constitutional provision. Thank you.
Yes, I agree with that, but do you have your own view on this stated misbehavior? Because you are a member of the bench, would you want to express a view, I mean, outside of the other definitions in other jurisdictions? Would you look at it from the ethical point of view or a criminal conduct?
Thank you, Honorable. If we look at the law, it talks about misconduct. And misconduct, it doesn't say criminal misconduct. So it could be either criminal or civil, depending on the behavior of that person. Example, if I'm a judge, then, Honorable, you appear before me in court. I said, leave my court, don't come to my court anymore. Then I ask my usher to carry you away from my court. It is contrary to my ethics, and it is contrary to the code of conduct. And therefore, that one will amount to misbehavior. So you can get several examples depending on the facts in issue. Thank you.
Thank you very much, Honorable Minority Leader. That brings us to the end of vetting of the Honorable nominee. May I proceed to acknowledge the guest of the nominee. First on my list is Mrs. Agnes Akosua Edujemfi Adjei. I believe that's the spouse of the nominee. Then we have Reverend Father Andrews Campbell. We have Bafo Adjei Fosu Chuchikwa II, Asantehene Anantahene. Then we have Nana Kwesi Oko II, Manso Tetremhini. Then we have Obrimpom Hima Dechi, Paramount Chief of Upper Discourse and Overlord of Discourse. We have Nana Asamoah Tia II, Mpatum Hini. We have Mr. Joseph William Baini, Professor Rose Emma Mama Entua Mensa. We have Samuel Ado Otu Esquire. We have Justice Eric Che Bafo, Justice of the Court of Appeal. We have Justice Efia Sawa Asariboche, Justice of the Court of Appeal. We have Justice Charles Edward Eko Bedi, Justice of the Court of Appeal. We have Justice Christopher Acha, Justice of the Court of Appeal. We have Justice Kizita Kowa Kwashi, Justice of the High Court. We have Majib Rahman Ahmed Esquire, Bafo Asari Krantin Esquire, and the Chief Justice and other justices of the Supreme Court that I have earlier acknowledged are also present with us till now. May I use the opportunity to welcome you and thank you for coming. Honorable nominee, we thank you very much for attending upon the committee and answering questions. You are discharged, but you will hear from the committee.